Good morning, friends. Today I am going to take you through very important aspects of intellectual property rights, that is the patent. I will cover from business perspective what are the various key requirements of the patents, what is the typical process a patent application has to go through in India, and the third most important point, what should be the critical points you must have in your mind while running your business and building your patent protection portfolio. So let's move to the first aspect, which is the key requirements of a patent application. In India, patents are granted under the category utility patents. You must have heard of design patents also, but design patents are protected in India under the Design Acts. We typically refer design patents as industrial design registrations. Okay, so whenever we speak about patents in India, it is always about product patent or a process patent. Either the product patent or the process patent is covered under the Indian Patents Act 1970. So either your inventions are focused on product or the process. Another important thing you must be very clear about any invention is that who are the inventors. The person who conceives the idea is an inventor. A person who developed the idea is not an inventor. Okay, then the second part is applicant. Okay, who is going to be the applicant for the patent application which you will be filing in India? It could be the owner, it could be the company name, it could be the inventor's name also. Okay, but you have to be very clear beforehand filing of the patent application in India. So what should be the content of your patent application? You must have heard about a term claims. Okay, these are the protection boundaries for your invention. Every claim has to be novel, every claim has to include an inventive step, and every claim must have industrial utility also. Once these conditions are satisfied, in India we have an additional requirement, which is that the claim should not fall under the scope of section 3. So once these three conditions are met, you are ready to prepare your patent application, and then your patent application will go through the various stages within your company, within your patent attorney, and within the patent office, and that's how your patent application gets granted. So let's have a brief overview of the patent examination process in India. Typically, when you have an idea, you always try to scrutinize that idea from different lenses. It could be a legal scrutinization, commercial scrutinization, as well as the technical scrutinization. So what is meant by this is that not every idea is worth enough to file for a patent application. So you need to understand, okay, what are the legal complications involved for filing a patent application, what are the commercials involved in launching that particular product, okay, what are the technicalities involved in drafting a patent application. So all these particular lenses you need to apply upon, you need to apply these filters on the idea, and then only you proceed further for the creation of intellectual property rights. So once your idea is clear from the internal department, then you decide, okay, what kind of application I need to file. It could be a provisional application or it could be a non-provisional application, depending upon the urgency of filing your patent application. We need to understand is that across almost all the countries in the world, everywhere it is first to file system. A person, if there is a competition between two inventors or the two applicants for seeking patent protection over a substantial similar idea, the applicant who has filed first will get the priority over the other applicant. So that is why it is also important for you to select when you wish to file a provisional application as well as when you wish to file the non-provisional application. So in preparation stage, you typically conduct a patentability search. You then with this type of patentability search, you will get an idea of the scope of protection, and after that then you draft the patent application as per the required specifications, whether the provisional application or the non-provisional application. Once you have the complete set of documents or the draft of your patent application, which includes drawings, which includes specification and the claims depending upon provisional or non-provisional, then you file the patent application in India or outside India. So it's again a strategic decision you need to take. If you wish to file a patent application outside India, then there is a 12-month window available for you to file an application outside India, either through the Paris Convention or through the PCT International application. And if you do not wish to file an application in India, you can file directly outside India, but in that case you have to comply with certain provisions of the Indian Patent Act, like for receiving foreign filing permissions from the Indian Patent Office. So once the patent application is filed, it is bound to be published in the official journal of the Indian Patent Office. The publication can happen automatically at the expiry of 18 months from the date of earliest priority date, or it could publish early also, depending upon the request for filing of early publication. So once application is published, the time period for pre-grant opposition is now open. Any person in the public can oppose your application during this stage, as well as your application will be sent for for examination purpose also. So what happens is that the patent office has the set of examiners who belongs to the same field in which the invention is being filed. They will issue a certain set of procedural objection as well as substantial objections, where they may raise questions over the novelty, over the non-inventiveness of the invention, as well as the invention falls under section 3 of the Indian Patent Act. So once that examination reports is communicated to the applicant, the applicant needs to submit the response within typically 6 months, and then if you apply for extension, then you have to pay some certain fee, and after that you will get additional 1 month period, 2 month period, or 3 month period, depending upon the extension fee you have applied for. After filing your submissions or responding to each objections raised by the patent office, the patent office will issue an in-person hearing, which you or your attorney will appear in that hearing and will try to respond to the objections raised by the controller during the hearing process. After that, if all the objections were removed and the applicant has complied with all other requirements of the Indian Patent Act, the patent is granted. So that's where your patent rights are there. And obviously, like any physical property, you have to maintain that physical property also in similar way. The patent also needs to be maintained. You have to pay annual maintenance fee to the Government of India in order to ensure that you want to enjoy 20-year time period for the patent protection. So now, what kind of patent rights you get after obtaining the patent protection? Let's discuss a bit on that. So what kind of patent rights you will have? As I told you earlier, that in India there are two types of patents. One is the product patent and second is the process patent. The product patent will protect you or will give you exclusive right against the third parties from manufacturing, from using, from offering for sale, from selling, or from importing that particular product, which is protected by the patent rights. And similarly, if you have a process patent, then you can protect yourself, or then you can enforce your patent rights against any third party from using that process, from offering for sale that process, selling and importing any product which is obtained by that process. So in the process patent, you get the protection on the process as well as the product manufactured from that particular process. However, there are certain exceptions are always available under the Patent Act. I will not go into the particular sections, but you need to understand that if the government wish to use your product patent or the process patent, they can use it under the various sections are available. Then India also has compulsory licensing related provisions, parallel import related provisions, and other provisions are available to protect the traditional knowledge of the Indians. So now we have understood what are the key requirements of the patent, what is the typical process by the patent office, and what kind of rights we get. My simple question is that does patent gives a right to patentee to sell its own product or process? So here the answer to this question is very important. We need to understand is that patent is an exclusionary right. It excludes others from manufacturing, using, offering for sale, selling or importing. Okay, but in a context when you wish to manufacture, when you wish to use it, and when you wish to commercially supply or outside India, okay, or when you wish to import particular product or a process in India, then you need to ensure two things. One is, it's good you have a protection on your particular invention. At the same time, you need to ensure that when you are manufacturing that particular product, okay, then you do not infringe someone else's intellectual property rights. You do not infringe someone else's patent rights. Okay, so unless and until you do not infringe someone else's patent rights, you are free to sell your own product and process. So when you are running your own business, it is important for you that you register and enforce your patent rights, and it is equally important for you to not to infringe competitor patents, not to infringe any third party patents, because if you infringe someone else's intellectual property, the relief available to third party are equal reliefs which are available for you to enforce your patent rights. So it is very critical for the business owners to understand this aspect, because we have seen many examples, many instances where the business owners file one patent application for a particular product, and then they see that okay, we have now the patent protection, we can launch the product, and later on they find out that the product requires licensing from other competitors also, so that they can run the business in the market without any litigation issues. So if you wish to prevent the litigation, you need to ensure that you register as well as enforce your IP rights. In the same way, you ensure that you do not infringe competitors or any third party intellectual property rights. So that was a very brief presentation on the patent rights. If you have any doubts, any questions, do write to us, and I will try to respond to your queries as soon as possible. Thank you and take care.